Warahmatullahi ta'ala wa barakatuhu. Greetings of peace to everyone. I am Charmaine Joyce S. Maningo and my partner is Ms. Shara Julia A. Castillo, and we are going to discuss about nationality and statelessness as part of our requirement in our subject Public International Law under Attorney Katrina Vanessa Y. Hagorilis. To begin with, let us define what is nationality. Nationality refers to a relationship between a person and his or her nation, or in legal terms, a country, for example, a place to whom a person has or is claimed to owe his or her origin, culture, familiarity, association, affiliation, fidelity, and loyalty. The nationals of a country generally possess the right of abode in the territory of the country. Other definitions of nationality according to Oppenheim is that nationality of an individual is his or her quality of being a subject of a certain state. According to M.P. Tandon, nationality is the character or quality arising from membership of some particular nation or state which determines the political states and allegiance of a person. And according to Heide, nationality is a relationship between a state and an individual which is such that the former may regard the latter as owing allegiance to itself. Now let us define what is citizenship. It is a term denoting membership in a political community with full civil and political privileges, and this membership implies reciprocally a duty of allegiance on the part of the member and duty of protection on the part of the state. This legal relationship involves rights and obligations on the part of both the individual and the state itself. Who is a citizen? A citizen is a person having the title of citizenship. He is a member of political community who enjoys full civil and political rights and is afforded protection inside and outside the territory of the state. Citizenship and nationality are not always synonymous. Citizenship is applicable in determining the status of a person. On the other hand, nationality not only denotes the identity, it may also refer to ownership. For example, an aircraft, ship, or company. Nationality is wider than the citizenship. All citizens are nationals of a state, but all nationals may not be citizens. What is the distinction between citizenship and nationality? First, citizenship follows the exercise of civil and political rights, whereas nationality does not necessarily carry with it the exercise of political rights. Second, a person can be a citizen of a country and a national of another. How is the term national distinguished from nationality? National is defined as a person who owes allegiance to and is entitled to the protection of a given state, regardless of the status under domestic law. Now, nationality is oftentimes used synonymously with citizenship. They are not exactly the same thing, for the first has a broader meaning than the second. All persons are nationals, but not all are citizens of a state. Citizenship implies complete possession of civil and political rights in a body politic, whereas the nationality does not necessarily confer these rights. What is the importance of nationality? First, protection of rights. Protection of rights through the diplomatic channel are in consequences of nationality. Second, jurisdiction of state. State exercises jurisdiction over civil and criminal matters over the persons of its nationality. Third, practice of state during war. During war, enemy is determined on the basis of nationality. Fourth, refusal to extradite. State can refuse to extradite its own nationals. And fifth, responsibility of state. States shall be responsible for harmful acts committed by their nationals if they allow them to commit. A person may acquire nationality by birth in two ways. A. Use soli or use loci. The place of birth serves as the basis for acquiring citizenship. A person becomes a citizen of a state where he is born, irrespective of the citizenship of the parents. It is nationality according to territory or locality of birth. Second is jus sanguinis. Nationality may also be acquired by a person on the basis of the nationality of either parents. It is nationality according to the nationality of the parents. Blood relationship is the basis for the acquisition of citizenship. The children follow the citizenship of their parents or one of them. Naturalization. Through naturalization, an alien by birth acquires the nationality of the naturalizing state. First, in marriage, the wife assumes her husband's nationality if the latter is the national of another state. Second, legitimation. A legitimate child acquires the nationality of his father. And third, an option. If a person fulfills the requisite conditions prescribed by the law of any state, he may be offered nationality by that state. In the purchase of real estate, an alien who buys a real estate in a foreign land can get the rights of citizenship if he so desires. Naturalization by domicile. If a person keeps domicile of a state, he or she also gets the nationality of that state. Next is by government service. If a person gets government service in a state, he or she acquires the nationality of that state. Next is permission by state to apply. If the law of any state permits application from persons for conferring nationality, such person may get nationality if they prove their eligibility. The third mode of acquiring nationality is called reintegration or resumption. Acquisition of nationality by resumption means to resume the previous nationality. Sometimes it may happen that a person lost his nationality due to several reasons, so subsequently, he may acquire the nationality of the previous state. Number 4 is by subjugation. In case of conquest of a state by another state, all the citizens of the defeated state become the nationals of the conquering states. The mode of acquisition is said to be acquisition by nationality by subjugation. And number 5, by cession. When a state or part of a state is ceded to another state, all the nationals of the former state acquire the nationality of the state in which their territory has been so merged. Number 6 is by option. Nationality may also be acquired by option in case where a parent state has been partitioned into 2 or more states. In such a case, the inhabitants have an option to acquire the nationality of any of the successor states. And lastly, by registration. Nationality can also be acquired by the legislative or administrative act of the state. The laws as to acquisition of nationality by registration are different in different states.
Modes of losing nationality. There are 6 modes of losing nationality, although all 6 are no means recognized by all the states. First, we have release. Some states, such as Germany, give their citizens the right to ask to be released from their nationality. Such releases, if granted, then nationalizes the released individual. It is effected by submitting an application by the nationality holder. If the application is allowed, he or she may lose his or her nationality. Second, deprivation. Some states provide deprivation of nationality in certain circumstances. If a national of a state gets his or her appointment in another state without seeking prior permission of his or her state, he or she will be deprived of the nationality in that state. Expiration or residence abroad for long period. If a person resides for a long period in abroad, his nationality is lost. Some states have legislated that citizenship expires in the case of such of their subjects as have left the country and stayed abroad a certain length of time. Option. For example, some states, Great Britain for instance, which declare a child born of foreign parents on their territory to their natural born subjects, although he/she becomes at the same time, according to the municipal law of the home state of the parents, a subject of such state, give the right to such child to make, after coming of age, a declaration that he desires to cease to be a citizen. Fifth, substitution. Loss of nationality of substitution occurs when a person loses nationality of one state and acquires nationality of another state. According to the law of many states, as for instance Great Britain, the nationality of their subjects is extinguished ipso facto by their naturalization abroad, be it through marriage, grant or application or otherwise. Some states, however, do not object to their citizens acquiring another nationality besides that which already possess. 6. Marriage. Women lose the citizenship of their original state if they marry aliens. In England, there is a move to retain English citizenship for women marrying foreigners. Distinction between nationality and citizenship. As it is obvious, nationality is a relation of a person with the nation of which he has nationality, while at the other hand, citizenship is the relation of a national with the law of the state. In other words, national enjoys certain legal rights while citizen enjoys absolute rights in the state. So nationality may be the subject of international law as well as municipal law, while at the other hand, citizenship is the exclusive subject of municipal law. As to relation, the difference between nationality and citizenship is that nationality is the relationship between national and individual, while citizenship is a relationship between the persons in state law. As to right, a person may get international rights by getting nationality of a state, while the rights of citizenship are concerned with the state law. As to scope, the nationality has wider scope, while citizenship has less scope. And as to law, nationality concerns both with municipal law and international law, while citizenship concerns with municipal law only. Dual nationality. A dual national possesses the citizenship of more than one nation. An individual may acquire dual nationality because, first, he or she was born in a nation that applies the jus soli rule of automatic nationality by birth. Second, simultaneously acquire the parent's citizenship when their home nation applies the jus sanguinis rule of parental nationality. The unusual burdens as a result of dual nationality are, first, the jurisdiction, second, the taxes, third, military service, and fourth, protection when he or she is harmed in a third nation. Corporate nationality. Siege social is a concept in international law for determining the nationality of companies. Accordingly, a company's nationality derives from the place where the legal entity's judicial and economic integration is situated, or in other words, the company's principal place of establishment. The Philippine nationality law is based upon the principles of jus sanguinis for right of blood and therefore descent from a parent who is a citizen or national of the Republic of the Philippines is the primary method of acquiring Philippine citizenship. So here in the Philippines, citizenship may be acquired by birth and naturalization. Statelessness. A person is stateless if he or she is not considered as a national by any state under the operation of its law. Individuals are stateless when they lack the nationality of any state. Loss of one's original citizenship, typically conferred by birth or parentage without obtaining a new citizenship, renders the individual stateless. The individuals cannot claim the band of citizenship with any state to protect them, and there is no state to come to aid of an individual who is in need of diplomatic representation. That's all for today's video presentation. Thank you for watching.